Good morning, everyone. This is Melody Pazalt from the Healthcare Authority, and we'll get started in just another minute or two as folks get logged into the system. And so thank you for joining us today for our second presentation on behavioral health and the intersection with the justice system. And so we'll get started. Welcome to our webinar. Hi, welcome to our monthly webinar. Thank you all so much for joining. My name is Melody Pazalt. I am with the Healthcare Authority in the Division of Behavioral Health and Recovery. And just a little bit of housekeeping before we get started. If you're not familiar with GoToWebinar, there's two options for talking or chatting or asking questions. And so one option is for you to dial in and use your telephone or your computer and speakers. We do prefer telephone because we get less feedback, and so that's your first audio option to either hear the conversation or participate if you want to ask a question. The best strategy is to choose the telephone option and then follow the dial-in information. The second option, if you have a question, is you can type the question into your question box. So that's another option to be able to check on the webinar or ask questions of our presenters. We'll get started in just another minute. So welcome to our webinar. Just a little bit of history about this webinar. And so the Healthcare Authority and the several divisions within the Healthcare Authority have started to meet to start talking about how we have different divisions that have behavioral health programs that are interfacing with the criminal justice system. And so we started wanting to learn more about our programs within the Healthcare Authority, as well as the different programs that are happening out in communities. And so we started creating this webinar series to really just increase our own understanding of what's happening, and we hope that you all benefit from these webinars as well. Here is a list of the topics that we have coming up, hopefully in the future. So we're looking at, for March, LEAD, the Law Enforcement Assisted Diversion, possibly the Co-Responder Program, the Snohomish Program's been doing some fantastic work, the Jail Transition Program, programming in jails with substance use disorder, medication-assisted treatment, the Department of Corrections housing voucher programs. We have lots of different strategies and ideas that we want to do presentations on over the coming months. The Offender Reentry Community Safety Program, a True Blood update, Oxford Recovery Houses, enhanced peer support services. So we have lots of ideas. If you have an idea or a webinar that you would like to hear about, please let us know. We are happy to take those ideas, or if you're interested in presenting, please send me an email. We'd be really happy to host a webinar as well. So to get started, last month, just as a reminder, we did an overview of the sequential intercept model, and all of our webinars kind of are in line with these different intercept points. And so today you're going to hear from Tim and Heather to talk a little bit about another Intercept point in terms of prosecutorial diversion. And so this is just a great reminder about the SIM model, and we do have the webinar that has been recorded on the SIM and the PowerPoint slides available from last month's webinar as well if you would like to learn more about the SIM sequential intercept model. With that, I'm going to turn it over to Tim Hunter from the Department of Social and Health Services and Heather from King County, and to talk a little bit about prosecutorial diversion. Tim?
Great. Well, first of all, thanks. And it's great to be able to, first of all, just learn about this monthly webinar. I think this is pretty exciting to be pulling people together and learning about what we've got out there and how these different pieces fit together. So thank you for the opportunity to join and to be able to talk a little bit this morning about the work that we're doing in DSHS around prosecutorial diversion. So in terms of the sequential intercept model, I always think about that as kind of off-ramps on the road to incarceration. If we can intervene and intercept 0 and do preventative things, or if those don't work and somebody does end up in a contact with law enforcement at intercept 1, what kinds of things can we do there to try to deflect people from arrest? This would be if we've gone past that point and there was a decision to arrest, then the question is, do we really need to prosecute? And so under these programs, the work that's happening is that prosecutors, defense counsel, the individual involved, and behavioral health staff all collectively consider the possibility of, might this be a circumstance where we could consider deflecting this person from prosecution if there's an agreement that they will participate in a pretty comprehensive set of services to try to provide supports and provide the kind of services and supports that will help this person meaningfully be able to avoid the kind of prosecution trajectory and rather get involved in a supportive set of services and hopefully be able to be successful in the community. So we're at fairly early stages with this work. I think that the first patients, participants began in late 2016 and early 2017. We fund these. We're thankful for getting some state dollars to be able to fund 3 sites that are doing this work. And so we have contracts that we put out an RFP and funded 3 sites, which are the Benton, Franklin counties, where the provider entity and leadership entity is the Lord's Counseling Center. And then in Spokane, it's a Spokane County Community and Human Services Department. And in King County, it's with the King County Behavioral Health and Recovery Division at the county that is the leadership entity there. And in each site, there are really strong partnerships with prosecuting attorneys, defense counsel, jails as well, and the provider groups. Once there is a formal participation agreement that's signed, where it says, yes, I, Tim, as the participant, agree to participate in these services, prosecuting attorney has signed this agreement, defense counsel has signed it, and the behavioral health group has signed it, then the person is formally enrolled into the program. And program participation can run anywhere from 6 to 12 months. In some instances, we've extended that where it seems like somebody's making progress but would benefit from some further involvement. And the kinds of things that people participate in would be having really frequent case manager contact, typically 3 times a week to start, and that may taper as things go on. But so there's very intensive involvement and engagement and high contact, right? And then also within that, trying to provide supports around housing, substance use treatment, getting connected with medications, medication management, and that kind of comprehensive, almost, reminds me almost of a PACT team in a way. It's very frequent engagement, very intensive services. and frequent loops back to inform all the partners about how's it going. Let's see, the sites are each operated a little to a fair amount differently. And we kind of allowed for that. That is to say, we just presented in the RFP kind of the big idea here, the components of this program. Please tell us how you'd go about doing that. So I think probably Lourdes and Spokane are on the two ends of the continuum, and King is kind of in the middle in terms of how they're structured. By that I mean in Lourdes, you can go there and sit around the table, and there will be a half a dozen or better staff that are all Lourdes Counseling Center staff who are involved in all the aspects of the program. And then they have a monthly meeting that also includes the partners that are prosecuting attorneys from, there's the Tri-Cities area there, so there'd be attorneys from each of the cities and from the two different counties as well. And I should say that the county and city prosecuting attorneys would respectively have more in the county level felony cases, and the city prosecuting attorneys would be dealing more with misdemeanor cases. Either are eligible for the program as long as everyone involved agrees it's appropriate in terms of public safety for this person to be in the community in this kind of program. So at Lourdes, it's very much kind of the Lourdes Counseling Center as the entity that has really taken this on and has a pretty robust team. Spokane, on the other end of the continuum, has more of a sort of contracted out type of model where they have a couple of county staff that are directly funded by the program, but they also then engage with service providers who might be with any one of the 5 contracted MCOs in the area. And so they might say, well, if Tim's involved, let's see now which MCO is he associated with. And well, Melody is with a different MCO, so she'd have a different team and case manager. So that's a little different there in terms of how they approach it. It's more of a sort of, as they say, contracted out kind of model in Spokane. King has one principal contracted entity that they work with, Community House, that provides the direct services to patients there. And they work closely with my colleague Heather, whom you'll meet later this morning, and her prosecuting attorney's office that I believe is with the City of Seattle prosecuting attorney's office. And again, they take different kinds of referrals from different courts. The Lourdes program takes referrals. They get quite a few referrals from jails, from law enforcement. They really kind of widened out and have more doors open, that they have just built relationships and have people coming in that then get to that review process by prosecution, defense, behavioral health, and the individual involved. So through this, what we're seeing is that there are choices where it can either be, in some cases, before charges have been filed, or it can be that the charges have already been filed, but then upon signing the participation agreement, all involved agree that the charges will then be, at that point of signing the participation agreement, the charges would be dismissed without prejudice, meaning that then if the person gets into the program and things don't work out, or they were to get rearrested for something of a serious nature, that then the charges could be brought again. However, should the person successfully complete the program, and then there's a formal, certificate of completion and hopefully a graduation ceremony and that kind of positive celebration, that then there's also then formally dismissal of the charges with prejudice. Charges cannot ever be resurrected and brought again. So we're seeing people who are being deflected from prosecution, in many instances also deflected from participation in the competency system. For instance, that the folks may have had people identify, well, we think that this individual in going forward to trial we would need to look at the question of competency. Sometimes even before the competency evaluation is ordered, the person gets into this diversion program, and then they say, well, let's forget about the evaluation then. And we've had a number of evaluations that get quashed or rescinded, and the prosecuting attorney will go into court and say, we no longer need that court order, or one never gets established. So I work in the office, the DSHS Office of Forensic Mental Health Services, where we have far more competency evaluations than we wish we did. This is one effort where we're able to think that we're bending the demand curve to have fewer people who need competency evaluations because they're getting involved in this kind of progressive diversion program. So that's a bit about the program in general. Going forward, we'd like to see the program expand because we think it's making a positive difference. We get monthly narrative reports from each site as well as a monthly data report in terms of sort of the program analysis and program evaluation effort that we could then use to sort of build the case for the program and study its impact and how could we enhance it, et cetera. Our friends in the DSHS Research and Data Analysis Shop have replied to our questions about that by saying, well, we think that we would love to do that kind of analysis and think it's important and would be valuable. However, we think it's too early to attribute any sort of cause to the outcomes that you're seeing. And what we would like to do is wait until there are at least 200 people who've been through the program, completed it, and then had at least 2 years since program completion, so that we could have that amount of time to say, well, what happened in this person's experiences in terms of the number of hospitalizations or involuntary treatment experiences they've had pre and post program involvement, how many arrests, incarcerations, those kinds of things. What was their experience with homelessness and housing pre and post? So they wanted to make sure that we have a large enough group of people for it to be significant and reliable, and also a long enough period of time to be able to see some life experience go by. And then what they've told us they would like to do in terms of a design for evaluating the program would be to take that cohort, the first 200 people who've now been out of the program for at least 2 years, and then construct a matched comparison group, people with similar utilization of mental health services, similar diagnostic presentations, who did not participate in this program, and then compare the two groups so that they could look at some differences. And then they're saying that at that point, as our research professionals, they would think that they could conduct a meaningful study of program outcomes. And we think that we will be able to do that by something like spring of 2021, if all goes well. So it's a ways down the road. Meanwhile, I get these monthly reports, and in each of them, I ask each site to produce something that would talk about an individual story. So these kind of anecdotes about Juliana entered the program on this date. Here's what had been her experiences over the past couple of years. She's now involved in the program. Here's what that involvement has looked like, and here's her current status. And interestingly, when we presented that through our assistant secretary up to the legislature, it's those stories that have really grabbed people and that people have responded to, and those seem to be compelling individual stories of people's lives changing. So we believe these are strong. We'd like to be able to support the program going forward and keep it growing, both in terms of the number of participants that each site is able to serve each year. We'd like to increase that. And then also look at the possibility of adding additional sites as we go forward. So I hope that gives some sort of general sense about the program. In terms of sequential intercept model, we would think this exists at Intercept 2. Post-law enforcement engagement and arrest, but pre-going to court. And so we think this is an Intercept 2 intervention that we're, as I say, pretty early into, but have, we're at least up to our knees in the pool at this point, and have built some effective partnerships within these 3 sites and look forward to continuing. But at that point, let me just pause and Melody, I'm not sure what would be best in terms of should we maybe let Heather proceed, then do some questions after they've heard. Okay, so let me introduce then my friend and allow her to further introduce herself. But Heather is an assistant city prosecutor at the Seattle City Attorney's Office and has been a strong partner in this this effort up in King County since its inception. And so Heather would have a more specific view on this from the eye of an attorney, considering public safety and also managing the flood of cases coming into the court. How do you manage this and select people and go through the process from her perspective? So Heather, could you please take it from here?
Sure, thanks, Tim. Good morning, everyone. Thank you for this opportunity to speak about prosecutorial diversion from the perspective of my office, which is the Seattle City Attorney's Office. After a quick introduction about myself, I'll provide an overview of 3 programs that I oversee for my office. So LINK, which is what Tim has been talking about, Legal Intervention and Network of Care. And then I'll touch briefly on 2 other programs, Law Enforcement Assisted Diversion, or LEAD, as well as the VITAL program, which is a Familiar Faces Initiative program. So again, my name is Heather Amon. I've been a prosecutor with the Seattle City Attorney's Office for 18 years. Prior to becoming a lawyer, I spent 6 years in social services. My first year as a Jesuit volunteer at a downtown shelter, and then the following 5 with Children's Home Society of Washington as a child and family advocate. So one would think the natural transition for a person from social services would be to become a defense attorney. So I did try that for my 3rd year of law school. However, I quickly learned about the power of the prosecutor and their ability to really make a difference. Prosecutors determine whether to file charges, what charges to file, and how a case will proceed in the criminal justice system. So my first real job following law school was in prosecution, first with the King County Prosecuting Attorney's Office, and then for the last 18 years with the Seattle City Attorney's Office. And throughout that time, I have never taken the power of the prosecutor for granted. So with the Seattle City Attorney's Office, I spent 15 years in mainstream prosecution. In mainstream prosecution, you have the 4 corners of a police report and the 4 corners of a person's criminal history to try to figure out how to make a recommendation that would address the underlying cause of the criminal behavior. What is going to help this individual reduce their impact on the community and their contact with the criminal justice system? As you can imagine, that's almost impossible to do when you don't know anything about the individual. What are their barriers? What are their benefits? What is their family structure? What is their stability? Unfortunately, you're not likely to get a lot of that information from the defense attorney because it's not their role necessarily to share that information. Their role is to represent their client and what their client wants. And I'm sure you can imagine the client wants, usually, out of jail. And so defense attorneys are in the position of representing what their client wants, and that may not actually be what's in the best interests of the client. So when the city is able to be partnered with prosecutorial diversion programs like LEAD, LINK, and VITAL, the city is just better equipped to make informed decisions about how to proceed with charging decisions and the negotiation of cases to ensure victim and community safety that do not set the individual up for failure. And what I mean when I say that is oftentimes an individual is willing to agree to treatment as a condition of sentence simply to have a reduced jail sentence. And yet they really have no means of being successful with that particular condition. So I've been overseeing LEAD, LINK, and VITAL programs for my office for the last 3 years. These programs are designed to provide alternatives to mainstream prosecution for individuals having contact with law enforcement where unmet behavioral health needs are the basis for the contact. These programs can help reduce the impact the individual is having on their community, which obviously is the goal of the prosecutor's office. And then it also can reduce the harm the individual is causing to themselves. So it's really a win-win for both the community as well as for the individual themselves. So Tim did a great job talking about Link and introducing Link. So a little bit from my office's perspective. So Tim, my office does have a fully funded full-time prosecutor dedicated to just Link. It is not myself. I do oversee the design of the work that happens and am very closely aware of what it is that my office is doing. So every morning, the Link prosecutor meets with our partner, which is Community House Mental Health Agency. They meet at the filing desk. The prosecutor is reviewing the session sheet for all individuals that have been booked into custody, either on new cases or on bench warrants. What she is looking for in that initial review is what are the eligible crimes that we might be willing to make a referral to Link for. She is also reviewing all of the cases that are set in our mental health court. Seattle Municipal Court has a dedicated mental health court that operates Monday through Friday. So cases that are direct set in that courtroom are all reviewed for Link, and you can imagine that the good majority of referrals that we make are cases that are set in that courtroom. After it is determined who might be eligible, then that individual's criminal history is reviewed. Currently, the city will not refer, and I believe this is consistent amongst all three programs, but currently the city will not refer individuals to Link that have pending charges or convictions for violent offenses or sex offenses, as outlined in RCW 994A030. You can imagine that those charges are pretty obvious. They're murder, kidnapping, and that type of charge. However, individuals facing charges for eligible crimes who don't have disqualifying conviction history and who don't have other holds will be reviewed then with our partner to see if the information that they have with the database that they have access to is Link going to be a good fit. I don't have all the information as to what is in the database, but I know that there is enough that Community House is able to determine that the person would benefit from services. So if that person doesn't have any social services contacts or there's no history of competency raises or there's no other flags that Community House, based on their own screening process, which is independent from the Seattle City Attorney's Office, if they determine that that individual is a good referral, then the city will make a referral on those cases. When a referral is made and charges have not been filed, the individual is provided with a letter that tells them what the expectation of the Seattle City Attorney's Office is in order to not have charges filed. And Tim alluded to this. He indicated that they need to agree to participate. But really what the City Attorney's Office is looking for isn't necessarily an agreement to participate, but just really that first touch. The charges that the city are willing to refer to Link are nonviolent property crimes. So the city is really wanting to introduce this individual to a program that, if they are willing to engage with, has the potential to help them address the underlying cause of the criminal behavior. The city is not making it a requirement that they engage, but the city does require a meaningful first contact and that they develop an individual care plan. And as the city understands it, what happens in that process is that the individual is having a conversation about there are barriers to success. You know, maybe they need an ID, they need to get connected to benefits. So they just have that opportunity to explore with an individual, you know, how can I move myself forward? And if the city gets information that that individual care plan has been completed, then the city is agreeing to decline that report. Now, if that person returns to the criminal justice system on a new charge, the city will make another new determination whether or not to make another referral to see if that engagement can be increased, or if the city intends to proceed with mainstream prosecution. So, because of the nature of the type of crime that the city is willing to consider, the city is only seeking that initial care plan in order to not file charges. If the city attorney's office has already filed charges and the person is still at the initial stages of the criminal justice system, the city is willing to make a post-file referral, in which case the city is still seeking the same thing. The city is still seeking evidence that there has been that meaningful initial contact where an individualized care plan has been developed. If the city gets that confirmation, then the city will dismiss that filed case. Again, these are all nonviolent property crimes that the city is considering at this time. Now, I say that with the caveat that when competency is an issue and an individual is repeatedly having cases dismissed for competency, and they find themselves in that gray area where they're not legally competent to proceed with their case, but they are also not enough of a danger to themselves or others to be ITA'd, then we do expand our criteria as to what charges we might consider for a referral, because the city feels very strongly that this is someone who's caught, as I already indicated, in this sort of gray area where they're not receiving services. So if there's not a significant community safety or victim safety concern, or maybe I should say if there's not an immediate community safety or victim safety concern, the city wants to make that referral in hopes that that engagement can begin and that criminal justice cycle can begin to be addressed for that individual. So it's a real interesting process. We ran for purposes of this webinar, we ran some numbers just for January, and our office screened over 300 individuals just in the month of January for possible referral. 200, let's see. So about 2/3 of those individuals were screened out either because the charge was not eligible, they had disqualifying pending charge or conviction, they had other holds, they didn't appear for court if they were out of custody. There's a whole slew of reasons, but about 2/3 got screened out of those 350. It looks like we screened in January. So we ultimately vetted with our partner about 141 individuals for possible referral, or 150 individuals for possible referral. And Community House, based on their screening process, determined that only 13 of those would actually potentially benefit from services based on their information. So you can see there's a lot of work that goes into trying to make this opportunity available to individuals, and we're averaging, I think, my office with our current criteria, we are averaging between 12 and 15 referrals a month to Community House. So you can imagine that's keeping them pretty busy when they do have a limited number of folks that they can serve on a regular basis as a current pilot program. So that's probably that's what I have to share about Link. I don't know if we want to open up to questions about Link before I continue with Lead and Vital, or I'm open to suggestions there.
Thanks, Heather. I do have a comment from Jim. The shortcomings of the police department program are twofold. One, you have to plead guilty to the charge, and two, you must commit to actually completing the support program for which you sign up. In the case of people with serious mental illness, the likelihood of their actually fulfilling their contract of support is inevitably iffy, with the ability to complete the support program often due to their illness. Even with program support, check out the outcome percentage of these programs as far as successful completion. If a program claims success, then make a further check into the program's criteria selection for participation. If the program and then the severity of the illness of the individual selected for the program, you find the ones who need the program the most are selected out of because of denial to the access to the program. I think his comment is really about how do you know if your program is really serving those folks with the most complex challenges with their serious mental illness.
Yeah, this is Tim. I'll take a poke at that. And hi, Jim. Haven't had a chance to talk with you for a while. It's good to connect via this webinar. First of all, the person doesn't have to admit to any wrongdoing in this matter in terms of the criminal case. They've been arrested, but this would deflect them from going forward into any criminal proceeding. So there wouldn't be a trial. They don't have to say anything about the criminal case to participate, just that they would participate in the service program. And then, you're right that this is going to be folks who have perhaps complex, multiple needs. A lot of our folks need housing support and need different kinds of support and treatment services. A couple of things about that. One is that we've had some people who've gone through the program and at the end of a year period still need ongoing support. And we've been able to accommodate that and continue the program for people when that's been appropriate. We've also had people who went through the program and it wasn't a good fit for them, and they've come back around a second time, and folks in the program have reviewed the case and said, well, we'd like to do this again, and had people enroll a second time. Another variation has been, I was at a local meeting with a team that was doing this work where a prosecutor said that the team was asking, gee, if somebody has now had a rearrest, does that mean we must bump them out of the program? And the prosecutor said, oh, please don't do that. We've seen this person typically several times a year, each of the last few years, and we're not that concerned about the new charge, or we don't consider that to mean that this is not effective. We think this person's actually making improvements, and the fact that they've been arrested for this new charge, which we don't consider a grave matter, we sure hope you wouldn't need to pull the person out of the program. And I've told them, no, from the state perspective in our contract, that's not at all a requirement. But it really is up to the local team to make a decision about what's working. So all those things to say that we would like to think that we're making this program kind of low barrier in terms of how people can get in. They don't have to be clean and sober. They don't have to confess to having committed a crime. And then that we'll try to meet them where they are and provide the services and supports that we can. So I don't know if that's helpful, Jim, but I wanted to offer those thoughts.
Heather and Tim, this Melody, I was wondering if you could explain, or I've heard this term recently, and I didn't hear, Heather, you may say the term, but presumptive dismissal. And I was wondering if you could address that. Is that part of the prosecutorial diversion, or is that something completely separate?
So it's not a term of art for our office. Perhaps other jurisdictions use that. There's nothing that's presumed other than if they complete that individualized care plan, then the city will either decline to file a new report or dismiss the filed case. So the city is simply asking for that one step, and then the city will follow through with what it promised as part of that agreement. So I want to echo from what Tim said in response to Jim, that the city, in the Seattle City Attorney's Office, the individual is not entering a plea. And I think Jim is definitely highlighting that there is a population that Link is just not going to be able to serve. And I think that that's why, at least, especially here in King County, it's so great that there are so many different programs that can try to serve populations and really have very specific specialties as to what they do. But I would say this about Lead, Link, and Vital, that each and every one of them is not necessarily a great program for everyone, but it will work for some, it won't work for all, and we just need to keep striving to reach those populations, especially, Jim, the one that you mentioned. I think it's a really challenging population, especially if they continue to find themselves involved in the criminal justice system.
Heather and Tim, this is some of the perks of actually hosting the webinar, is I get to ask a lot of my own questions. And I have a document up that's posted on the DSHS website that kind of talks about the differences between the grants, the contempt fine grants that were given out versus the settlement agreement versus the prosecutorial diversion projects. In the settlement agreement, there are forensic navigators that when somebody is in that process of possibly being evaluated for a competency evaluation or going to outpatient competency restoration, and I imagine even in somewhat of the prosecutorial diversion that there's somebody that needs to make sure that that person is doing what they're supposed to be doing. In your guys' program, in the prosecutorial diversion pilots, is there somebody like that forensic navigator? And has the courts ever thought about using peers, people with lived experience, as that role?
Well, this is Tim. I'll take a quick poke at that and then ask Heather to add. Yes, there are roles like that at each of the sites in terms of the navigator really being an intensive case management kind of presence, that the navigator is helping the person navigate their way through the different expectations, and if the person is supposed to go to court, that they know that, if they need to get to their medication prescriber, that they have help getting there if necessary, that kind of thing. So the intensive case management is definitely part of each of these sites. And again, just in terms of nomenclature, when Heather refers to LINK, that's the name that locally the Seattle folks have given to the prosecutorial diversion program as it's managed there. So that's when you see the name LINK, just so you know. Let's see, the other thing I wanted to mention is that at each site, there is also a strong presence of peer specialists as part of the program too, and I think that's a really important, maybe essential component of the program. But Heather, would you add anything? Or?
So, let's see. So when our office looked to partner with Community House and make referrals to Link, my office made a commitment to really trust Community House. So when it comes to what happens after the referral is made, other than that confirmation that that care plan's been completed, there's just trust that Link case managers and the intensive case management team is holding up their end of the bargain, so to speak. So they've agreed to provide intensive case management to that person in exchange, as part of our working relationship. So my office does not necessarily get into the inner workings of what happens when a person is enrolled in the program. I do know that locally here, Community House does have a peer specialist position.
Have anything on the website? Thank you, Heather. So if folks do have questions, I will just remind them to either raise your hand and I can unmute you, or you can type your question into the question box. But at this time, Heather, we don't have any additional questions, so if you want to go ahead and keep going.
Okay, I'll just quickly go over. So law enforcement assisted diversion is another program that I oversee for the Seattle City Attorney's Office. Most folks know it as LEAD. LEAD kind of falls in between Intercepts 1 all the way out to 3. And I say that because law enforcement can divert an individual into LEAD and connect them immediately with intensive case management services. Or individuals can be referred by way of a social contact, which means they may find themselves more in Intercept 2 or 3. But also, once a person is enrolled in the program, then the role of the prosecutorial liaison in my office is to track that individual. So whenever a new report comes in, I get flagged. Whenever a person gets booked into jail on a Seattle Municipal Court charge, I'm going to get flagged. So I know that next month's webinar is about, sort of what is LEAD, so I don't want to spend a lot of time talking about that and steal the thunder from the greater presentation, which does really involve, and I hope that panel would include members from all the different stakeholders, because the success of that program really is the collaboration of law enforcement, prosecutors, community, and defense. And I mean, it would not be where it is today 8 years later without folks really wanting to work together to see that there is an alternative to simply booking and mainstream prosecution. So when we began in 2011, it just started in a small neighborhood. It's now in all 4 precincts, and hopefully we'll be in the 5th one shortly. What the city is able to do with these individuals, with the enrolled individuals, is partner with the case manager, who can provide the city with the information that's needed to really make individualized plans that address the underlying cause of the behavior that the individual can be successful with. And it's really hard to put into writing like what that looks like, because it really is so individualized. A higher functioning person, there's going to be a higher level of expectation. LEAD clients have varying needs, from very extreme, including the true blood population, to just someone who maybe is struggling a little bit due to homelessness, and maybe there isn't even a substance use or mental health component to what they're experiencing. But the goal is to really try to wrap our arms around this individual to try to remove them from the criminal justice system by addressing what it is that got them there in the first place. So LEAD's been very successful for anyone who's been tracking it, and at this time, referrals are only being taken new referrals are only being taken by law enforcement, and that's because of capacity and staffing issues. But once the funding is back in place and staffing is in place, LEAD hopes to open up the referral process so that if there are members of the community, including defense attorneys, including prosecutors, that see someone struggling and that could benefit from outreach services, that is someone who could be enrolled. The value of this is I no longer have to just look at the 4 corners of a police report and the 4 corners of a criminal history to determine how to best break the cycle for that person. So when these reports come in, if a person is doing well, I have the ability to not file that report. Maybe I will outright decline that report. Maybe I'll hold that report to see how the person engages. So there's so many different stages that we're able to work with LEAD enrolled clients in the criminal justice system. Even if charges are filed, the disposition then is the next place that the matter can be mitigated, whether the charge is ultimately dismissed or whether there's an agreement of some sort to comply with certain conditions in order for the case to be dismissed. But there's so many different places that the city can intervene for lead clients to try to reduce their contact with the criminal justice system. And I'm really fortunate that the Seattle Municipal Court has set a Wednesday morning calendar, so I'm going to be rushing from here to there. There's a Wednesday morning court calendar that is dedicated to lead and vital clients. I'll speak about vital briefly in a second. And the beauty of that is that now we have an opportunity in the courtroom to change the messaging for individuals. As you can imagine, lead enrolled clients have had a lot of contacts with the criminal justice system. They come in, they get told, prosecutors saying, you're bad, we're charging you with this, and the judge says, I agree with the prosecutor, and this is what I'm going to do to you. And it's really not about what the individual is and who the individual is. And lead brings that to the courtroom. Now when we, if charges are appropriate, we are still able to sort of humanize the experience for the individual in the courtroom. We spend a lot of time talking about information about what the client is doing to better their situation. And we'll talk about the smallest of small things in order to show that person that we see them, we see what they're doing. And currently the judge that oversees this calendar is Judge Damon Shadid. And he really believes in, he really understands, I should say, harm reduction, has a great understanding of lead and vital. And, his messaging to individuals is, I'll try as long as you're trying. So, you can imagine the success that we're able to have when we have all of these people, from the reach case manager to the prosecutor to the court, and then the defense attorney as well, to the extent that they're able, again, given what their role is, really trying to come in and break that cycle. So it's really pretty powerful. And just in the interest of time, I'll just say Vital is a much smaller program. It's currently a pilot program. There's only 60 enrolled clients at any given time, whereas I'm tracking approximately 1,000 in the lead program. And Vital also, by design, has an intensive case management program that individuals have access to, and that team also communicates with my office, and we're able to make the same considerations that are made for lead clients. The difference being the way you get into Vital is it's based on your jail utilization. So individuals are put on a list that have been booked 4 more times in a 12-month period, and that's happened twice in a 3-year period. So there's no referral process for that pilot at this time. The hope is that there will be one in the future. So the entry points are different. There's no law enforcement component with Vital, but the way the prosecutor is able to operate with that information is very similar. The goal is to not use the information to have worse outcomes for individuals, and we work really hard to not have that happen. The reality is that if a person is not engaging in the program, then they will be prosecuted the way anyone else would be prosecuted in the office. I still oversee those cases in order to sort of ensure some consistency in how those cases are prosecuted. So those are the 3 programs that I specifically oversee that address individuals who have unmet behavioral health needs and or experiencing homelessness. And it's really been incredible to be able to prosecute this way. It's absolutely my hope that we're able to do this in the future this way. My office has other pre-file programs that are focused on 18 to 24-year-olds, as well as driving programs. But for purposes of this conversation, I think those 3 programs that I oversee are probably the most relevant. So anyway, I'm sorry, I spoke really fast. Hopefully some of it was valuable, but it's, any questions?
Heather, thank you so much. We did have a question that came in, and can you describe what are the 4 corners again?
Oh, so it's just the way I referenced it. In mainstream prosecution, you're just looking at the police report. So you're reading what the officer wrote down about what happened. And so you're just reading the narrative of the police report. So you're restricted to that, and then you're looking at the four corners of their criminal history. So what is their conviction history? So it's very limited information. You sort of have that one incident and their criminal history, and you're trying to make a determination about what is an appropriate sentencing recommendation that will address the underlying cause that this individual has the potential to be successful with. And it's close to impossible to do that, which is why the information that we have when prosecutor offices are partnered with these outside programs is we have that additional information to really humanize the process, but really bring that human element into the courtroom to help that individual be successful. So it's sort of putting our money where our mouth is, I guess, so to speak. It's very easy to think that as a prosecutor we're doing the right thing, but we're really, that additional information is really necessary for individuals to be successful, which is what the city ultimately wants. We're wanting to reduce their impact on the community, and we're wanting to reduce the harm that person's causing to themselves.
This is Melody. I think that all of the folks on the webinar are saying that they would probably like to clone you as a prosecutor in their region. So you sound just incredibly compassionate, and so really appreciate that. We just got another question in from Pam, and she's wondering, are risk assessments a part of the consideration process?
No. Not in terms of when we think of a risk assessment. From our office, a forensic risk assessment would be a pretty intensive enterprise that would include a couple of standard instruments. Typically involved in that process will be the HCR20, a tool that psychologists use in the kind of art and science of trying to predict future risk of what an individual's behavior in the future might be. And that's a fairly intensive procedure that's both using some psychometric instruments and interviews that then leads to a report that tries to address that question of, gee, what might we be able to predict about future risk? No, there is nothing that is done in that kind of formal way about a risk assessment in these matters. It's more like, as Heather was referring to, looking at what's in the four corners or what's on the paper when you've got a police report, what's on the paper when you look at the person's criminal history, and then what do the behavioral health people know about this individual? And in smaller communities, it's easier than if you're in King County where Heather's got 1,000 people she's tracking. In the smaller communities, like over in Benton Franklin, they can say, yeah, we saw George again, and say, oh yeah, over by the Walmart, and everybody knows who George is. So it's different in different communities to be able to get information about people, but it's really just what do the people in the room know about this individual, and what do those documents about criminal history reflect. So no, there's not a formal risk assessment.
And I'll just add, sorry, Melody? So just a reminder that my office is prosecuting misdemeanors, and I'm not trying to minimize those crimes. The DV, DUI, all the more serious crimes are definitely looked at with a different lens, but there is no formal risk assessment. It's just an individualized assessment. The city is not going to make a referral where victim or community safety is an issue, a referral to link, and the city is not going to necessarily mitigate cases for lead or vital enrolled clients where there is a victim or community safety concern. So, but it's more on an individualized basis and not a formalized risk assessment tool base.
Thank you, Heather. Tim, Heather, thank you guys so much for your time today. We so greatly appreciate the information. Up on the screen are some screenshots or links to the 3 programs that Heather leads in King County or in Seattle. So, again, thank you all so much for your time today. We really appreciate it. Our next webinar will be March 25th, and so we'll be sending out the announcement for that. This webinar was recorded, and we will try and post the recording as well as the slides that we have for today's webinar. So thank you all so much, and thanks for joining us. And again, we hope you enjoy these webinar series, because it really is just an opportunity to learn more about what's happening between the intersection between behavioral health and the legal system. So Thank you, Heather, for your time. Thank you, Tim, and hope everybody has a great day.
Thank you.
All right. Thanks, Melody.